I think the process can deem adopted. We can proceed, my lord.
Okay, and that is what everybody is saying.
Yes, my lord.
My lord, we can read.
Okay, you were saying something, Council. That
My
you
lord,
can
I said we can readopt.
Oh, okay. But and where is Patience? Let her call up the matter. Patience, yes, are you there?
Yes.
Yes.
Okay, my lord. Resume that.
Yes.
Resume that Lagos Day, Friday, 27th May 2022. Before His Lordship, Honorable Justice M.N. Sowe. Case number NICN/CA/15/2018. Finance Bank Limited.
Okay. Appearances then. Appearances.
May it please the Honorable Court. Kelvin Otiku. My humble appearance is for the claimant.
Kelvin O.
Tiku. T-I-K-U, my lord.
Yes.
My humble appearance
for the claimant.
Yes, my lord.
Yes. Very well. Yes.
My lord, I appear for the defender.
Okay. Yes,
I appear with I appear with O.E. Esquire. C.E. Ita. O.E. Okun Esquire. C.E. Ita.
Okay.
C.E.
Of course, I know you, sir.
Esquire.
Yeah. Okay, another Ita. It's C.E. Ita.
Yes, my lord.
Okay, you are in your
my own is
you are appearing with
NTA.
Okay. His own is
O.E.
ITA.
Okun, then C.E. Ita.
Okay. For the defendant.
Then M.O. Edet. M.O. Edet.
Okay. M.O. Edet.
M.O. Edet. My lord, we all appear for the defendant.
Very well.
Yes, sir.
So, like before, this judgment should have been given by Tuesday last week. So, Tiku is of the view that you should readopt. So, I don't know which one we shall do, or deem your adoption to have been, deem your final written addresses to have been adopted.
Yes, my lord.
Yes, my lord.
So
because of the network, I think with consent of my learner senior, I think we will deem the process to be adopted, my lord.
Very well. Okay. Today. So have been adopted.
Network is bad.
Right. I go on and I deliver the joints. Yes. This suit was instituted by the claimant by the complaint dated the 21st of March 2018, where the claimant the following leaves a sum of 9,024,753 naira 50 kobo, being the outstanding balance of retirement benefits and gratuity to the claimant from the different calculated on a half-year assessment basis at 2,578,501 naira per annum. Hello?
Hello, we are here.
Here.
Okay. 2, the sum of 30,537,125 naira, being the starting balance of monthly pension arrears from 2007, calculated at 1,804,950 naira, 7 kobo per annum. 3, total claim of 22,561,878 naira, being outstanding balances of retirement benefits and gratuity due to the claimants, calculated on a 3.5-year assessment basis at 2,578,501 naira. Yes, per annum, and outstanding balances of monthly pension arrears from 2010 to date, commencing from 1995 to 2007, calculated at 1,804,950 naira, 7 kobo per annum. 4, 21% interest on the said sum of 22,561,000 879 from them when the claimant retired from the defendant services. 5, 10% interest on the judgment debts commencing from the date of judgment till the final liquidation of an perpetual injunction restraining the defendant either by herself, agents, privies, assigns, or any other person or persons acting on her behalf from intimidating, harassing, inviting, arresting the claimant, his agents, privies, assigns, or doing anything whatsoever and on the defendant to pay the sum of 10 million naira only as general damages to the claimant for the blatant failure, neglect, and or refusal to pay the claimant his retirement benefits, gratuities, and for the harassment and torment sought by the claimant therein. A summary of the facts of this case will show that the claimant, until his retirement, was the pioneer managing director officer of the defendant bank. The claimant served the defendant bank for 15 years, starting from 1995 and 25th of October 2010. The claimant had to retire on 25th October 2010, having attained the 60-year retirement age. After retirement, claimant having attained the claimant waited for the defendant to pay him his retirement benefits. Data 17. The claimant, by the letter dated 5th June 2017, entitled Application Regraduation, Gratuity and Pension, applied for his retirement benefits, pensions, and gratuity. In response to the same letter, the defendant, via a letter dated 2nd November 2017, admitted indebtedness to the claimant to the tune of 341,543 naira 68 kobo, being the pension benefits in favor of trade benefits were computed to us. Annual emoluments 2 million 578 years work, 15 years. Outstanding loan 815,456 naira 32 kobo. 4,341,543 naira 68 kobo. Claimant Aveza by the defendant on 2.5 years assessment at 2,578,501 provided for in defendant's manual of operation for staff 2009. Furthermore, that the claimant never received any demand notice of indebtedness from the defendant. He, however, saw by chance the stated amount on the 12/13 financial statement of the defendant. He immediately wrote to the MDCEO by the letter dated 28 March 2016, demanding for the details of the loan, but no response has been made till date. Despite defendants admitted indebtedness to the claimant, she failed to pay the claimant. Rather, oh, Jesus. Yes? Okay, I can't see. Okay. I'm so sorry, there was an outage. So, rather, in a letter, hello, Council, are you hearing me?
Yes, my lord, we are hearing you.
We are hearing you, Lord.
Okay, even though my voice is echoing, rather, in a letter dated 2nd November 2017, the defendant requested for the sum of 161,625,486 naira 60 kobo as total loss suffered by the defendant during the claimant's tenure as the managing director of the defendant bank. The claimant advanced further that after his retirement, the defendant disengaged the then external auditors and appointed another auditor, Fry Archibald and Son and Co., which carried out audit of the defendant's books and completed all the debt entries during the reign of the claimant, and came to a fallacious conclusion that the defendant suffered a loss of 160,067,032 naira 28 kobo, attributable to the time of the claimant was MD CEO. Consequent upon this, a query was issued to the claimant, to which the claimant reacted to. After the foregoing incidents, nothing happened until the claimant made a request for the retirement. The failure and neglect of the defendant to accede to the application for the payment of the claimant's retirement benefits has led to the nature of the relief sought in this suit. On the part of the defense, in her statement of defense filed on the 18th day of April 2018, the defendant stated that the claimant was indicted in all audited financial reports for the period ending 31st December 2008, wherein all audited financial reports for the period ending 31st December 2008 were financial irregularities in the defendant bank were exposed. That when a new auditor was brought in, it was discovered that some schedules supplied to NDIC examiners were all at variance with the respective balances in the general ledger. The defendant stated further that the 2009 manual of the defendant operation quoted by the claimant was a draft document which was not approved by the board of directors. That the approved policy documents in force at the time the claimant retired was the manual of operations, since the defendant was incorporated as a community bank in 1995. The provision, the RAT makes provision for 2 years annual emolument as gratuity. That from the available records, the claimant owes the defendant 815,456 naira 32 kobo, and the claimant knew about this, though he suppressed his loan documents until his retirement. Besides, the entitlement of the claimant, which is 4,341,545 naira 68 kobo, was set off against his liabilities to the defendant, totaling 165,967 naira 32 kobo. Oh, I was right. 165,969,032 naira 28
Kobo.
falsification and manipulations of records by the claimant during his time of directors to explain and defend himself on the mammoth financial irregularities that took place during his reign as MD CEO. He pleaded for pardon and forgiveness, claiming that the financial irregularities observed were window dressing, used to keep the bank going and operational. The defendant therefore states that the claimant is not entitled to any of the reliefs claimed in this suit. On receipt of the defendant's defense, the claimant filed a reply dated 27th November 2018. In the said reply, managing director of the defendant, he rendered meritorious services and he never operated in isolation of any regulatory by the defendant's board of directors, internal and external auditors, NDIC examiner. Such reports never indicted a claimant of fraud or forgery. The claimant the finances of the defendant, and there was no time the claimant recorded losses.
Because it was window dressing.
In the hearing of this suit commenced on the 20th day of June 2019, to which the claimant himself testified as CW1. He adopted his witness statement on oath of 2020. On her own part, the defendant opened her defense on the 20th out Eden as DW1, who identified himself as a banker with the defendant. He adopted his witness statement on oath, tendered documents admitted as exhibits on behalf of the defendants, and was cross examined. The defendants was found to enable parties file, exchange, and adopt the financial and ceremony. Council.
Yes, my lord.
You are hearing me.
We are
Yes,
hearing you.
yes.
Everything is breaking, but we are hearing you, my lord.
Yes, my lord.
Okay.
We're hearing you.
Because from where I am.
But we didn't hear some parts, my lord.
Okay. That is
Yes.
why I want to suggest council, both council that and by you could be skipped by the court so that the court can go to its findings. Yes, because
yes, my lord.
Exactly. Yes, my
Yes,
lord.
my lord.
We agree, my lord.
Okay, because I just hope that we will end up. From here, I am hearing my voice. It is echoing seriously, and I don't know why. So I'm going straight.
Yes, my lord. We agree, my lord.
Conclusion.
Go to your
Okay.
As the court pleases.
conclusion, my lord.
Please, OG on Esquire. OG on Esquire.
Let us hear the conclusion.
Okay, this is the court decision.
As the court pleases.
Yes, having gone through the case of the claimants,
Yes.
defense of the defense are trial. This court has still the sole issue for determination, and that is to say whether, given the circumstances, the capital claim of 22,561,879 naira only. Yes. Being inside this sum, the claimant is claiming the sum of 13,537,000 naira. Being outstanding balances of monthly pension arrears calculated at 1,804,000 naira, 950 naira, 795 to 2007. That is for 12 years, which has not been paid since 2010 when he retired till date. The sum of 1,024,753 naira 50 kobo outstanding balance of retirement benefits and gratuity calculated on 300 as
What is she doing about what she's doing?
All that claims besides the foregoing are incidental and ancillary to the substantive claim of the claimant. Partly she did not file any set of or counter claim against the claimant. Their position is that the claimant cost the defendant bank a colossal loss of 168,967,032 naira 28 kobo. As such, on deducting the claimant's entitlement from the said sum, the claimant will still be the one owing the claimant. Given the nature of this case presented to the court by the claimant, and given the defense presented by the defendant before this honorable court, the court would look at how the claimant has been able to prove his case to be entitled to the relief sought, and also look at the defense of the defendant to determine if a valid defense has been put forward by the defendant. This is done in line with the decision of the court in University of Ilorin versus Rashidat Adesina, reported in 2010, 9 Nigeria Weekly Law Report, part 1199, page 331 at 348 to 349, where the court held, and I quote, by virtue of section 1371 and 2 of the Evidence Act, the burden of first proving the existence or non-existence of a fact in civil cases lies on the party against whom the judgment of the court would be given if no evidence were produced on either side regard being had to any presumption that may arise on the pleadings. If such party adduces evidence which ought evidence which ought reasonably to satisfy a jury that the facts sought to be proved is established, the burden lies on the party against whom the judgment will be given if no more evidence were given, etc. unquote. Therefore, in the case hearing, the court will look at the case of the claimant. If the claimant has discharged the burden of proof placed on him, while also looking at the defense up to the defense to see the defendant has led, if the defendant has led evidence in support of the defense, it has. It must be borne in mind of the parties before this court that civil cases, unlike criminal cases, are determined on the preponderance of evidence. As such, it is the party whose evidence preponderates that wins. In this light, a party whose facts or allegations are weighty, but with scanty or no evidence in support of such facts or allegations would end up leaving the court empty and fallow. Coming to the case of the claimant, the position of the claimant is that he's entitled to 3.5 years of his basic salary, annual salary as retirement benefits, and gratuity on retirement. He relied on the Manual of Operations for Crutech Community Microfinance Bank, Nigeria Limited, Calabar, 2009, which was tendered and admitted in evidence before this honorable court as Exhibit C2. In contrast to this, the defendant stated in paragraph 11 of the statement of defense that the said 2009 Manual of Operations was a draft copy which was never approved by the Board of Directors. That this can be attested to by several alterations on the documents. I have gone through the said 2000 Manual of Operations, 2009 Manual of Operations, admitted in evidence before me. One really needs to see the said documents to determine if it is a final copy or a draft copy. The first thing that caught my eyes is the series of alterations and mutilations by the use of biro on a print document. Printed words are altered with biro, numbers are altered with biro, and the alterations and mutilations were not done in few pages, but in almost all the pages. For the avoidance of doubt, the so-called 2009 Manual of Operations, tendered and admitted in evidence, contains 63 pages. Out of these 63 pages, it is only pages 1, 2, 4, 7, 13, 29, 32, 35, 36, 37, 39, 41, 43, 44, 46, 49, 50, 51, 57, 58, 59, 60, 61, 62, and 63 that were not altered or mutilated with biro. Imagine a document of 53 pages having 37 pages from pages altered and mutilated. It is a criticism. Some of the pages are so altered and mutilated that you can't even make sense of what is written there. Even page 56, which contains subtopics like conditions for enjoying seminar and mutilations. I wonder how the claimant as such altered and mutilated documents can be dumped on the court. From assessment of exhibit manual of operation for Protect Nigerian 2009. It is not a document that can attribute any probative value to, given the mutilation inherent in the document. Given the
that year, no, 3 years ago.
Okay, that time was that my sister's was before. After I changed them, it's not 10,000.
I did tell somebody to tell me. I'm very sorry. I don't know where this noise is coming. It is not a document the court can attribute any probative value to, given the and alterations inherent in the said document. Given the document that ought not to be admitted, it was wrongly admitted, and as such, the fact that befalls documents were wrongly admitted to be falling. Yes, in reported in 2013, 17 Nigeria Weekly Law Report, Part 1364, page 117. The Supreme Court held that when a document is wrongly admitted in evidence by the court, the same court has the power to expunge it at judgment stage, since it can only base its judgment on legally admissible documents. Evidence. Taking a cue from the decision of the Supreme Court above, the court thereby expunged from its record, and I so hold. Yes, having expunged Exhibit C2 from the record of the court is left with Exhibit D11, Polycal Community Bank of Nigeria Limited, Manual of Operation, which was tendered by the defendant and admitted by the court. From the facts and evidence I've used before me, there is no doubt that the defendant's hearing used to be Polycal Community Bank before it later became known as Protect Community Bank. The claimant attested to this paragraph 1 of this statement of fact when he stated the claimant is a retired banker and was the pioneer managing director of Polycal Microfinance Bank, now Christian and known as Protect Community Finance Bank Limited. Based on the foregoing, it leaves none of the parties in doubt that Polycal Community Bank Nigeria Limited and Protect Community Microfinance Bank are one and the same banking institution. That said, it can only be assumed that at the time the claimant became the managing director, being that he was the pioneer managing director, The manual of operations then was Exhibit D11. Therefore, if for any reason the claimant now says that there was another manual of operation that came into effect thereafter, the onus lies on the claimant to show proof. This arises from the settled principle of law that it is he who alleges that the claimant has not been able to show proof. Given the circumstances, the only document on which the court can calculate the terminal benefits of claimant is Exhibit D11, and I so hold. In Exhibit D11, Polica Community Bank of Nigeria Limited, Manual of Operations, Chapter 4, Paragraph H, provides gratuity. A retired staff shall be entitled to be paid a gratuity as specified below. 1. Pension scheme. The bank shall maintain a pension scheme of 500,000 naira, to which staff shall contribute to, and on retirement shall be drawing a percentage of his or her monthly pay as if it was still in the service of the bank. Then conditions of enjoying terminal benefits. 1 to 3 years service. No benefit apart from 3 months salaries, allowances, and unearned leave allowance. 4 to 6 years service. 6 months salaries, allowances, and unearned leave allowance. 7 to 9 years, 1 year salary, allowances, and unearned leave allowances as gratuity, and is entitled to monthly pension worked out on a percentage, that is 60% of monthly salary and allowance, as if it was still in the service of the bank. Then 10 years and above, 2 years salaries, allowances, and unearned allowances of gratuity as a monthly pension to be worked out on a percentage of the basic salary on board. Now, before proceeding, I would like to say that there are certain facts which are not in dispute between the claimant and the defendant, arising from their pleadings. As such, the court will not delve into solving the issues which are not contended by parties. This is so because the track law is that facts admitted needs no proof. See the University of Ilorin versus Rashidat Adeshino Supra. That said, it is not in dispute that the sum of 2 million odd is the sum the claimant is entitled to as annual emolument for the purpose of calculating claimant's gratuity. In this light, and arising from the provisions of Exhibit D11 highlighted above, what the claimant is entitled to as gratuity is 2,578,501 naira times 2, which equals 5,157,002 naira. And I so hold. Yes, in this vein, the calculation of the gratuity of the claimant is correct, as calculated in Exhibit C5, the original copy of the letter dated 2nd November 2017, titled Pre-Application for Retirement Benefits, Gratuity and Pension. Note, the defendant also tendered a photocopy of the said document, which was admitted as Exhibit D7, whereas the claimant tendered the original, which was admitted in evidence as Exhibit C5. Further, from the evidence before me, it is clear to both parties that pension payable to the claimant is from the claimant's pension administrator in the PENCOM Act. Therefore, the sum of 13,537,125 naira claimed by the claimant from the defendant in his claim 2 is bound to fail. And I so having heard that the claimant's gratuity is a sum of 5,157,002 naira. Yes. The court would now address the contentious issues engineered by the defendant, that the claimant caused the defendant a colossal loss of 465,967,032 naira 28 kobo, which, if deducted from the claimant's retirement benefits, the claimant will still be paying, and the other issue of the debt of the claimant is the result of loan collected from the defendant, which, according to the defendant, is 815,456 naira 32 kobo. On the colossal loss of 165 million odd, paragraphs 14, 16, 17, 19, 22, 24, and 26 of the defendant's statement of defense, the defendant stated that massive fraud and falsification of records were committed by the claimant during his time as managing director, thereby leading a colossal loss of 65 million odds. That when a claimant was called upon to address this massive loss, he pleaded with the Finance and General Purpose Committee and agreed that the financial irregularities were window dressings to keep the bank going. On the part of the claimant, in paragraph 4, 5, and 8 of the claimant's reply to the defendant's statement of defense, the claimant stated that there was no case of financial manipulation or fraud as managing director of the defendant's bank, not to talk of concealment of theft. The claimant denied any loss and or liability to the tune of the 165 million odd or any sum whatsoever. The claimant stated that such allegation was an afterthought. Now, given the allegation of the defendant against the claimant, what comes to mind? What comes to mind is whether the defendant has been able to prove the said allegations against the claimant. This is so because in the case of Skybank PLC and another, the Chief Bolanle Akingbe reported in 2010, citations supplied. Pleading is not tantamount to evidence. It was supported by evidence. In the case hearing, this court is more interested in evidence in proof of pleadings, as the court cannot take pleading on its face value. The point is that it is not enough to plead, but he who pleads must lead evidence in support of his pleadings. I have gone through the documents tendered by the defendant and admitted as exhibits before me. Exhibit D8 is dated 9 January 2012 with the subject report on financial and unethical practice in Crotech Community Microfinance Bank by Mr. Maxwell Evans and Mr. Francis Ukoyo. In the document, which is more or less question and answer series, there was no mention of loss of revenue or manipulation of funds. The loss of 165 million odds. At page 4 of the said document, which is the last page, and the recommendation page, it was recommended that the cash of 200,000 naira collected by Mr. Ukoyono for the perfection of Ogoja property be refunded by him, since the money was not spent for that purpose. There was no recommendation or penalty for the claimant, whom the defendant's bank now accused of causing a colossal loss of 165 million odd. The defendant, in his final written address, stated that the claimant used his position as managing director to falsify and manipulate the account records of the defendant to his favor, to cover and conceal several of his unlawful acts. He referred the court to Exhibit D4. Then the claimant embezzled and misappropriated several funds while in the employment of the defendant. He referred the court to Exhibit D7. Now, Exhibit D4 is a document titled Head Office Audit Report for the period ended 31st December 2008. From the first page to the last page of the said documents, there is nothing there to suggest that the defendant manipulated or falsified the records of the defendant. The claimant manipulated or falsified the records of the defendant, which caused the defendant a colossal loss of 165 million odd. Furthermore, Exhibit B7 is a letter dated 2nd November 2017, written by the defendant to the claimant. The said letter is titled Application for Retirement Benefits, Gratuity and Pension. The said letter thus in paragraph 3 however, you should recall queried on financial irregularities and unethical practices on the bank in the letter dated 27 June 2011, involving total losses of 165,000 odd, and you responded to your letter dated 15 July 2011. I must say that the fact that the letter was addressed to the claimant financial irregularity and unethical practices does not translate to the fact that the claimant is guilty. Furthermore, I have read the claimant's letter dated 15 July 2011, which was tendered and admitted in evidence before me as Exhibit 11. There is no way in that letter that the claimant admitted to causing such a colossal loss in that said letter. If the claimant never admitted to such colossal loss, if the defendant never led any credible evidence in proof of the allegation, I wonder how they want the court to believe the same, come to the conclusion that the defendant actually suffered such a huge loss during the reign of the claimant as the managing director. In all fairness to the defendant, it seems that the bogus loss that they claim wouldn't have come to light if the claimant never asked for the retirement benefits. It is therefore not surprising that the claimant referred to this turn out of events to be an afterthought. On afterthought, the Court of Appeal in Ugokwe versus Kemus Industries and Services and another reported in 2018 held as follows. As in regards of an application of Section 91(3) of the Evidence Act, now Section 83(3) of the Evidence Act 2021, let me say straight off that the general rule in law is that documents made by an interested party during the pendency of a suit is inadmissible. This section was enacted to render inadmissible a document prepared by an interested person in order to defeat through its clear wordings the cause of justice. Such a document is rendered inadmissible when the maker knows that the pendency of the suit to which the document is made, and even where he does not know about the existence of the suit, he anticipated that a dispute might arise, unquote. From the above, it is safe for the court to also say that documents prepared by an interested party to occasion injustice on a retired employee who now seeks his retirement benefits are afterthoughts. For all it is worth, the allegation against the claimant are crimes of financial fraud, which can be reported to the EFCC. In this light, if the defendant is convinced that it has a case of sordid financial fraud against the defendant, claimant, he should do well to report the claimant to the EFCC. However, as it stands before this honorable court, the defendant failed to lead evidence of financial fraud against the claimant. As such, the defense of the defendant, as well as his allegation of financial fraud against the defendant to the tune of 165 million odd, is bound to fail, and I so hold. The Supreme Court in IBWA Limited versus Emmanuel Nigeria Limited, reported in 2001, held, and I quote them, "It is a law that pleadings cannot constitute and does not tantamount evidence, and a defendant who does not give evidence in support of his pleading or in challenge of the evidence of the plaintiff is deemed to have accepted the facts in dispute as adduced in the evidence by the plaintiff, notwithstanding the general travis in his pleadings. Given all that have been said above, it will suffice to say that the defendant, having failed to give evidence in support of his allegation, pleadings of the 165 million odd loss against the claimant, is deemed to have accepted the fact as stated by the claimant that his allegation is an afterthought. If ever there was anything as window dressing, then it simply means that what was window dressed was money the defendant never earned in the first place. If therefore the defendant never earned what was window dressed, then there was no loss. Yes, moving on to the issue of loan collected by the claimant, which the defendant claimed now stands at 815 naira, 815,456 naira, 32 kobo. But the claimant claims he thought the sum to be 249,999 naira as contained in the financial statement of 2009 and had been liquidated and paid off before his gratuity will be paid to him by the defendant. See paragraph 3 of the claimant's reply to the defendant's statement of defense. But that as it may, be it as it may, everyone knows that if you fail to pay your bank loan, it keeps increasing. So much so, if the defendant had paid the claimant his gratuity since 2010, when he retired, and deducted the claimant's loan from the said gratuity, I'm not sure anybody would be talking of 815,456 naira, 32 kobo. In this vein, and for the purpose of justice and equity, the court will limit herself to what it stated as the loan debt of the claimant in the 2010 financial statement, which was tendered as Exhibit C12. In the said document, which contains both 2009 and 2010, the indebtedness of the claimant to the defendant was stated as 481,298 kobo. With regards to the position of the defendant that the claimant never tendered his employment letter before this honorable court, this court wishes to state that this is of no moment at all. Issues were not joined on the employment letter of the claimants. Rather, the defendant admitted to having employed the claimant. See the case of Dr. Aga Eresia Eke and 2 others versus Elder Jackson Orikoha and 2 others, reported in 2010, where the court held that facts not denied nor challenged, or which are admitted or deemed admitted, need no further proof. Therefore, in the case hearing, there is no issue at all on the employment of the claimant by the defendant. In any event, even if the defendant was to deny that the claimant was her employee and there was no employment letter, the court can, from the conduct of the parties, decipher if there was indeed employment relationship between the parties. From all that have been said above, the case of the claimant succeeds as follows. Claim 1 succeeds only to the extent that the defendant shall pay to the claimant the sum of 5,157,200 naira, being the correct calculation of the claimant's gratuity, minus the sum of 481,298 naira. Yeah. Being the claimant's indebtedness to the defendant as reflected in the 2010 financial statement. Claim 2 fails. 4, given the circumstances, the money sought as pension cannot be sought from the defendant, but from the pension administrator of the claimant. Claim 3 fails for the reason that it is a mere duplication of claims 1 and 2. Claim 4 fails. 4, given that the court had earlier limited the indebtedness of the claimant to defendant to 2010 without calculating other interests that may have accumulated till date, it is also necessary not to calculate any interest for the claimant on what the defendant owes him, so that equity can be seen to have been done to both parties. Claim 5 fails. 4, given the circumstances of this case, the court is minded to order a time frame within which all judgment sums are to be liquidated, rather than granting a percentage only on judgment sum. In this regard, defendant is to pay all judgment sums to the claimant within 30 days of this judgment. Claim 6 fails, for the court cannot stop any legal authority empowered to investigate or arrest the claimant from doing so if the claimant is found wanting or criminally liable in any matter connected to this case. Claim 7 succeeds only to the extent that the defendant shall pay to the claimant the sum of 500,000 naira only as general damages to the claimant for the blatant failure, neglect, and or refusal to pay the claimant his retirement benefits, gratuities, and for the embarrassment and torments suffered by the claimant therein. This is the judgment of the court, and judgment is entered accordingly.
As the court limits.
Okay.
My Lord, we are grateful for such an elucidate judgment. We are grateful. We thank you, my Lord.
Thank you very much. Thank you.
Thank you very much, my Lord.
There was a time there was some noise. I wonder if you were hearing. You were hearing the court. Anyway, you are still going to get your copies. So thank you very much.
Thank you, my Lord. We are grateful.
Yes. Okay. So I think that should be it. What do you know? We meet?
The one is what?
The one by 5 million, then he minus 470,000.
you share 800?
Success partial.
What is it?
What's the extent? Including the extent that
What is
we use
I was attending another course. Earlier online.
That one you were looking for. Claim 1.
within 30 days.
It was by their MD. They took a decision on the board. They call it a man. They went to her. So the data I didn't sign. Having stayed fine.
6 any ABC.
Claim 1, I don't understand. Claim 1 succeeds partial.
Succeed.